Good morning, good afternoon, good evening, everyone. Welcome to this webinar. We're going to be starting in a minute or so to let time for the participant to join. Welcome. Welcome, everybody. We're going to give just a minute to let participants the time to join. Good morning and good afternoon or evening, wherever you're joining from. We have quite a big group of actors registered to join today, so bear with us as we give a minute or so. Welcome, everyone. Okay, I think we're going to start this webinar. Welcome, good morning, good afternoon, good evening, wherever you're coming from. Welcome to this webinar. The first thing in terms of housekeeping is to say that you need to select your interpretation channel. We have Spanish interpretation. So make sure to follow the instruction, go to the little globe on the bottom of your screen and choose the language of your choice. Thank you. Next slide, please. So welcome, everyone. As mentioned, remember to select the interpretation icon and choose the correct language channel. We have Spanish interpretation today. Also to let you know that this webinar is being recorded and it will be made available to you in English and Spanish. Finally, for any question, please use the Q&A to ask questions. There's a Q&A function on your Zoom screen, and please make sure to use it at any time to ask questions so they can be answered during the Q&A session. So I will start again by introducing myself. I'm Florence Martin. I'm the Executive Director of Better Care Network, and I'm one of the co-moderator here. You're very welcome today to this webinar. So we are delighted to have this webinar. Better Care Network is delighted to be one of the co-hosts of this initiative, which brings together two critical communities and advocacy movements in human rights: the reform of children's care system and the advancement of children's access to justice. Both are intrinsically connected, and yet too often they operate in silos. Yet more integrated approaches are critical to realize the significant shift of paradigms, of systems, of services needed to realize both. So in today's webinar, we're going to hear from our amazing panelists about the ways children's care and access to justice are interlinked practically, including through concrete lived experiences and practices from diverse contexts. We will also hear about examples of ways of integrating our efforts more closely to strengthen both systems at national as well as at global levels. It's a particularly exciting time to do this. Global efforts to reform children's care, including alternative care systems, have seen significant momentum over the last couple of decades, with a redirection of efforts in particular to ensure every child grows up in a safe, supported, and nurturing family environment, and that we put an end once and for all to all harmful practices such as child institutionalization. The launch in September this year of a new global charter on children's care reform as part of a global campaign initiated by the UK government is mobilizing global commitments and action behind these goals. We're going to hear more today about the opportunity this provides from colleagues at the UK Foreign, Commonwealth and Development Office. Before going to our amazing panelists and speakers, it's my pleasure to hand over to my colleague and co-moderator, Professor Jennifer Davidson, who's the Executive Director at the Institute for Inspiring Children's Future at the University of Strathclyde. So she can say a few words about the exciting global paradigm shifts that are also happening on the child-centered justice front and the opportunity for us to integrate better our efforts. Jen, over to you.
Thank you so much, Florence, and a great big welcome to all of our participants today. Thank you so much for taking time and being what we hope is inspired by this opportunity to be thinking about these different movements and how they complement each other, and how together we can use these initiatives to be strengthening the outcomes that we're seeking together for children. So on behalf of the Global Working Group on SDG 16, Justice for Children, may I say we are delighted to be supporting this important webinar. And maybe just briefly, let me say that the child-centered justice movement, for which there is there's a UN resolution on people-centered justice and access to justice. There's a 2025 declaration on child-centered justice, and a great deal of activity that's going on around this space around access to justice and effective remedy that we'll be hearing about. And this child-centered justice movement calls for justice reforms to keep children and children's justice needs at the heart of justice reforms that are going on. And so I think today we are here with a collective concern about the human rights of those children who are at risk of being separated from their families, and those who are in alternative care, and those who are leaving care. And our focus today is on the ways in which children can experience just outcomes, when we think justice has a critical role to play in the advancement of children's care reform. And we want to explore that together with you. And so we're interested in your questions, and we're interested in beginning this conversation. And we hope that it will continue over the months ahead. So we feel it's a milestone opportunity to be thinking together and learning from a range of people who have been thinking about this for some time. And one of those people who has been doing a great deal of thinking about this and overseeing this work across justice and care reform is our opening speaker, who will be giving opening remarks. So, Shima, we're so delighted to have you here. Shima Sen-Gupta is the Director of Child Protection and Migration for UNICEF. She has over 2 decades of experience working with UNICEF across development and complex humanitarian settings, in which she has led programs that have focused on making sustainable changes in systems, in policy, and in service delivery for children and women. And so I welcome Shima here, who will be giving us really a framing of this sort of intersection of care reform and child-centered justice. Over to you, Shima, with a very enthusiastic welcome.
Thank you so much. I'm really, really delighted to join everybody for this global webinar on strengthening children's care reforms through access to justice. And just a small, I was saying to Kirsten and Grace, my colleagues working on this, that when I read these technical briefs, I was really moved by it, and really, really questioning why we didn't have this earlier, you know. So really very appreciative of all the work that everyone has done on this. And why is it so important? And really, access to justice it's key to ensuring accountability for children and young people who may be separated from their families or who are already in alternative care. And to make this accountability real, we must ensure that these children and young people, including adults who grew up in care, can claim their rights and seek remedies and redress for violations of their rights through legal process. Access to justice is critical to all judicial and administrative processes where children are at risk of being separated from one or both parents, and or being placed in alternative care, where family-based care, or whether it's family-based care or residential care. Excuse me. And yet, in many, many instances, far too many actually, children are being denied this right, especially in administrative processes, or limited in their capacity to exercise this right due to lack of effective legal representation or participation in the legal process, barriers in accessing complaints mechanisms, or justice systems that are not truly child-friendly. Children need access to justice in adoption and custody proceedings, in decisions to remove a child from parental care, as well as in decisions related to placement in alternative care. The Convention on the Rights of the Child is clear. Children shall not be separated from their parents against their will, except when competent authorities, subject to judicial review, determine that such separation is necessary and in the child's best interest. Access to justice is also key to protecting and addressing child rights violations in relation to children who are already in alternative care, or those transitioning out of alternative care. It's key to preventing and addressing serious child rights violations, including violence, abuse, neglect, exploitation, trafficking, and the worst forms of child labor. It is also essential to national inquiries and redress schemes addressing historic violations, including illicit practices in intercountry adoption, as well as structural discrimination that often leads to overrepresentation of children in extreme poverty, indigenous children, children with disability, and others in alternative care. To ensure that both children who are at risk of being separated from their families and children in alternative care can access justice and protect their rights, we need to reinforce the collaboration across the care and the justice sectors. And often in many countries that I've worked in, bringing these two together is really a big challenge. And I'm sure many of you today are experiencing that. So UNICEF's Reimagine Justice for Children agenda specifically recognizes the need to ensure access to justice for all children, including those in judicial and administrative proceedings, determining their care. And this requires countries to ensure child-friendly justice systems are available for children when their care and or placement is being determined and when they are in alternative care. Children must have timely and quality legal aid to enable their meaningful participation, as well as access to safe, independent, and effective complaint mechanisms. States must also put in place independent monitoring systems to prevent, receive reports of, investigate and address suspected cases of violations of children's rights in the context of alternative care. Systemic barriers to justice, including restrictive legal capacity rules, limited prescription periods, and lack of access to free legal services must be removed. States must also ensure accountability for violations of children's rights committed in the context of alternative care and should act to prevent future violations. And this includes establishing mechanisms to investigate and recognize the current, ongoing, recent, and historic harm caused by care systems, providing comprehensive redress to survivors, and fundamentally transforming systems to prevent future violations. National laws and policies should also support the meaningful participation in redress mechanisms of children in care or individuals formerly in care. And last but not least, oversight. Oversight is essential. In countries where decisions affecting children are taken by non-judicial or administrative bodies, there must be robust judicial review and accountability mechanisms in place. So to support these efforts, I'm really, as I said when I started, delighted to release today the new UNICEF Reimagine Justice for Children technical brief on children in civil proceedings. This brief explores how states can strengthen access to justice for children who came into contact with the justice system in civil proceedings, including when parents have disputes over their children. in matters concerning access, custody, guardianship, and adoption, or because an intervention is needed for their care and protection. UNICEF is also delighted to partner with FCDO, countries and other key global actors on the newly launched Global Childcare Reform Campaign. This collaboration presents a significant opportunity to advance comprehensive care reforms, including ensuring accountability, legal safeguards, and effective remedies are embedded within care systems. By working closely together, the justice and the care systems can ensure that all children can receive the care they deserve and grow up in a safe and nurturing family environment. So really delighted to be here and looking forward to seeing how these discussions go. Thank you.
Thank you so much, Shima, for articulating so well the different ways the justice system interacts with the alternative care systems and the work that UNICEF has been doing to ensuring child-centered justice. It's my real pleasure right now to also introduce our next speaker, who speaks from both professional and personal experience. Nimali S. Kumari, known as Nimu, is a caregiver from Sri Lanka and a leading advocate for children's rights and alternative care, drawing on a lived experience of over a decade in institutional care. Nimu currently works as the alternative family and foster care manager at Their Future Today in the UK and in Sri Lanka. She's also co-founded several caregivers network. She's also the award-winning author of a book just published recently, The Caged Girl, A Journey to Justice. Nimu, we're really thrilled and delighted to have you here today. Can you help us by bringing your personal and professional experience and expertise on the importance of access to justice in the context of children's care? We're really grateful for you to be here today, and we would love to hear from your experience. Can you share with us what you see as the main barriers for children to access justice in the care system?
Thank you so much, Florence, for the great question. I hope you can hear me well.
Very well.
Yeah, thank you so much. So, good afternoon, good morning, good evening, and I'm from Sri Lanka. So, I am Nimu. So, talking about the barriers for the children in care system to access the justice, I remind myself as an best example. So, I was only 11 years old, as I remember that I told to police that I can't be in my family with the abuse that happened, and they have taken me into the police and kept me in a prison until they get a decision on me. So it was 1 month I was in a prison and I don't know the reason. So, but anyway, finally they took me into the children home in 2001. So then it was an abuse case against my family. So I want to appear in court at least 3-4 times per year. So I used to go by prison bus in front of my school friends sometimes. So I go with the police. It was 20 years back story in Sri Lanka, which happened to me. But now system has been changed in Sri Lanka, but still that trauma not ended up from me. So it's also took me 8 years to stand up and say to the judge directly that I can't come again and again to the court and be re-victimized and saying same incidents, same abuse happens to me when I was kid. So yes, finally it's got over after 8 years, but still that trauma trigger when I see any prison bus on the road. So why I shared my real story here, not expecting any sympathy from anyone, but yes, empathy. So what I can share here, few point as a barrier to the children in care for the justice. Very first thing what it's coming to my mind is lack of awareness. Like many children in care may not be aware of the rights, their rights or the legal procedures available to the children just like me. So this lack of knowledge prevents us from seeking help or advocating for ourselves. So the second one, I guess, like emotional and psychological barriers, the most important thing. Children in care like me, like experience trauma and emotional distress. So which hide our ability to engage with the justice system. Even the fear and not being believed also maybe discourage us from speaking out. For the third one, like fear of speaking up. Like me, earlier, like children fear from speaking out because they think they might get moved another centers, because I was also transferred to 3 child development centers, like children's home. So the fourth one, I feel like lack of child-friendly legal process. So the legal process may not be designed with the children in mind, keeping children in mind, also making them uncomfortable and inaccessible. So child-friendly environments and procedures must be there. So last and not least, the most painful barrier, what I feel, fear of losing relationships. Like children in care always seeking for the love, care, and attention. So they get fear that pursuing for justice could break their relationship with the caregivers or the siblings or the friends they have created. So these concerns can like definitely deter them from reporting abuse or seeking legal resources. So which actually happened to me, and there are a lot of caregivers that who is not definitely coming out. So I know that there are time slot available for me still. So these 5 points I just wanted to highlight especially. So I just want to share these few points, and there are a lot of more barriers which I can talk whole day, which I can't stop, yeah, like talking. So addressing these barriers through advocacy, education, and systematic reform to ensure that all children in care have equal access to justice and can have their voice heard. This should definitely be happening. So as a caregivers, like we are sharing our thoughts in many summit, many webinar, and I wish the people who listen to me and will take an action on the point I have placed on here. This is not coming from any stories. This is a real stories coming from my end. Either the system is changed in my country, either system is changed in your own country. The trauma is never going to end. It should never come back to the other children who are living in children's home. So especially ended up the court cases of children in care before they leave the care institution is definitely must, because that's the place that they are getting the most injustice. After they get married, even they want to appear in the court. It's going to be definitely a problem for their family life, which I have been experienced with my other fellows. So this is the main thing that I really wanted to highlight. So, and get involved and participation children in care and also the caregivers when any legal policies is going to adapt for the children in their own countries. Because our participation, our own experience definitely must be there heard. Because the ground level thing is happen to the caregivers and children in care. Without their experiences, hearing all of you, that no one can like having kind of a policies and all. So I hope that time is getting past. So thank you for listening to me, and this is a great opportunity. And this is not only my voice, and this is for all the children in care and also the caregivers in the entire world. And those who wish to read my biography, it's on Amazon. Which name? It's related to our webinar today. My book is named as The Caged Girl: A Journey to Justice. So until we meet again, thank you all beautiful people, and best of luck for other speakers, and have a great day. Thank you very much for the opportunity.
Nimu, thank you so much for your contribution. I think you've left us with lots to think about. I think you've been really generous with sharing your experience with us for us to be able to learn and to change. And I think there's so much to reflect on. But just briefly, if I could say, Nimu, that I think you remind us of the harms that systems can create and the trauma, even when we're trying to help, the trauma that systems can continually reproduce. And so I think your contribution just brought such a humanity to the topic of what we're talking about today. And you remind us of the importance of this for so many children and young people and adults today for whom these traumas continue to reverberate. You talked about the importance of children's awareness of their rights. And I think that's just such a critical piece, isn't it? Everything you said was so important, but I think our awareness of our rights are so important, because if we don't know the law, we can't use the law. And I think in legal empowerment understanding, we need to know the law to use the law, and then we need children's voices involved in order to shape the law. So I think you bring all of that to our thinking today. And one other thing I'd like to highlight, although you said so much more to us, is I think you absolutely remind us that the trickiness about bringing together these two ideas of access to justice with trying to change care systems and improve them is that sometimes the access to justice part feels quite disruptive, and it can sometimes feel like you're going to interfere with relationships that are actually really important. And so I think let's hold on to that, because we'd like to come back to that in the questions and answers, and perhaps bring that to the wider panel, because I think that's at the very crux. What we're talking about today is, how do we support people who are working with children in the care system to be able to facilitate complaints in ways that don't damage relationships? Because if we can do that well, we can enable children to be able to raise concerns where they are important. And if we can't do that well, it's a continuing silencing of children that causes so much harm. So Nemo, you've given us so much. I want to thank you again for your generosity in sharing your experience with us. And I know that we are all humbled by hearing your story. And I'm delighted that there's a book that we can read to hear more about your experience. And we'll look forward to speaking with you further in the panel. Thank you again. We're going to turn now to our next speaker. I'm really delighted that we have an opportunity to be hearing from Esther. So we have today, Esther Valenzuela is a lawyer and international children's rights consultant. She serves as faculty at the Universidad Diego Portales in Chile, and is the director of its postgraduate diploma in children and adolescents' rights. She's the founder of La Voz del Niño, which provides legal counsel to children affected by rights violations. And Esther, among so many other projects, you've recently led research to inform a case study by one of the partners, in partnership with one of the partners of this webinar, the Pathfinders for Justice, for Just Peace and Inclusive Societies. And this is a case study that is on access to justice for children and alternative care in Chile, to better understand how children who are at risk of being separated from their families and those children living in alternative care can have their rights so much better protected. This is so interesting, this research. And I know that at the moment there's just a blog that's available, but in that January there will be the report available, and we will watch for that very closely. So my question to you today is, can you please tell us, why is autonomous legal representation and specialized defense by a child's lawyer, why is that so important? And maybe you could also say, to briefly speak about, in what ways can the kinds of mechanisms we've been hearing about so far, how can they prevent children's separation from their family, which is so important in this care reform agenda? And how can we ensure that these mechanisms make sure that children's rights are respected when children are living in alternative care? We're excited to hear from you. Over to you, Esther.
Bueno, muchas gracias por la invitación a un espacio que es tan importante, que permite discutir sobre un tema que es esencial hoy en día. Lo primero es señalar, a propósito del estudio que mencionaba Jennifer, que mi aproximación fue como académica, pero también como abogada de niños pro bono, que actividad que ejerzo hace ya más de 10 años. Lo segundo es que quiero partir diciendo que la prevención y la identificación temprana deberían ser la regla y no la excepción. Dicho eso, la premisa, bueno, lamentablemente cuando hay niños, niñas y adolescentes que han sido vulnerados en sus derechos, son víctimas de delito, es decir, que necesitan contar siempre con defensa, pero no cualquier defensa. Se trata de una defensa técnica y especializada. ¿Qué significa esto? Significa que el niño cuente con un abogado que maneje absolutamente la litigación estratégica, que maneje la interposición de recursos, que maneje además todo lo que tiene que ver con la trayectoria judicial para que tenga una efectiva defensa, que además este abogado sea especializado. Que sea especializado significa que no solamente tenga una trayectoria y una experiencia como abogado de niños, sino que además tenga formación específica en derechos de infancia, que no es lo mismo que tener formación en derecho de familia. Hoy en día tenemos una materia que se ha robustecido con los años y que necesita independencia. Y que ese abogado se dedique exclusivamente a los temas de derechos de infancia en su ejercicio profesional. Esta defensa, y a propósito de la pregunta de Jennifer, además debiese ser autónoma. ¿Ya? ¿Autónoma de quién? El abogado debiese ser autónomo de la familia, sobre todo y especialmente cuando es esta quien agrede, ¿ya? Quien ha vulnerado los derechos, pero también cuando la familia no es agresora. Y aquí simplemente quiero poner un ejemplo desde mi experiencia como abogada de niños en casos en que la niña es abusada por la pareja de la madre, el padrastro, desde el inicio no se sabe si efectivamente esta madre va a apoyar y va a creer a su hija o va a creer y va a apoyar a la pareja. Cuando ocurre lo segundo, bueno, esto es el tener una defensa autónoma es esencial, ¿ya? Es esencial siempre, pero les pongo un caso en el que es imprescindible y no puede negarse esta autonomía. Lo segundo es que esta defensa debe ser autónoma del Estado, ¿ya? Pese a que el Estado debiera tener esta oferta universal de defensa, especializada, interdisciplinaria, autónoma, el abogado debe ser independiente del Estado para poder demandarlo en caso que el Estado sea quien vulnera por ejemplo, a través de profesionales de residencias, de cuidado, en que de alguna manera estas residencias dependen del Estado y por lo tanto el Estado es quien debiese supervisar, quien debiese tener la diligencia para efectos de monitorear cómo están funcionando estas residencias y además porque se trata de niños que al ser separados de su familia están bajo el cuidado del Estado. La otra característica es que debe ser interdisciplinaria, ¿ya? Y en ese sentido, el abogado debe contar con el apoyo de un equipo psicosocial para trabajar la teoría del caso, para trabajar una estrategia, que en casos de infancia debe ser una estrategia psicosocio-jurídica, ¿ya? En mi experiencia como abogada, siempre digo que no habría podido ejercer como abogada de niños si no hubiese sido de la mano de psicólogos o trabajadores sociales que han sido un apoyo tremendo porque los abogados no tenemos esta formación de cómo entrevistar niños, de qué informarle al niño en materia de infancia y por lo tanto un equipo psicosocial es esencial. Por eso hablamos de una defensa especializada, especializada e interdisciplinaria y autónoma. En ese sentido, el rol de este abogado, apoyado por el equipo psicosocial, debe ser asegurar al niño su derecho a la información, porque de lo contrario, ¿cómo va a formarse un juicio propio para poder opinar? El abogado también debiese asegurar su derecho a ser oído, siempre, ¿ya? Distinto será como luego se evalúe su opinión para efecto de determinar su interés superior, pero debe asegurar el derecho a ser oído. Y lo mismo debe asegurar la posibilidad de impugnar sentencias o decisiones de un tribunal, especialmente en aquellos casos en que la separación del niño de su familia no esté debidamente fundamentada. Esta separación debe ser una medida de protección la última medida, no la primera medida. Quiero contar la experiencia de Chile a propósito del estudio que mencionaba Jennifer. Aquí en Chile, lamentablemente, a partir de múltiples informes emanados de organismos internacionales, universidades, instituciones nacionales de derechos humanos, se evidenciaron graves vulneraciones a niños que estaban en residencia, o sea, bajo el cuidado del Estado. El 2016 se presenta una denuncia por parte de un grupo de parlamentarios ante el Comité de Derechos del Niño, activando el protocolo de comunicaciones, y el comité concluyó, lamentablemente, que el Estado de Chile vulneraba sistemáticamente los derechos de niños, niñas y adolescentes que estaban en residencia. Bueno, las crisis siempre contribuyen finalmente a muchas veces a soluciones. Esta crisis llevó que en 2017 el Estado creó un piloto de representación jurídica llamado el programa Mi Abogado, el cual luego se extendió a nivel nacional. Y el 2023 implementó un segundo programa llamado La Niñez y Adolescencia se Defienden. Ambos programas aseguran una defensa técnica, especializada y autónoma, y además cuentan con el apoyo de equipos psicosociales, por lo tanto existe un enfoque interdisciplinario en que se trabaja de manera integrada, no solamente un grupo de profesionales que trabajan fragmentadamente, sino que hay un trabajo realmente integrado. Esto contribuye a lo que señalaba, la necesidad de elaborar una teoría del caso y una estrategia psicosocio-jurídica. Ambos programas se guían por principios y también por enfoques, ¿ya? Y esto ha contribuido a buenas prácticas. Pongo el ejemplo de enfoques intercultural, de género, de protección reforzada, y esto de verdad ha sido esencial para un buen desarrollo de una defensa que vaya más allá, ¿ya? Quiero señalar que UNICEF Chile ha sido y ha tenido un rol muy importante porque ha colaborado con el desarrollo, por ejemplo, de estándares jurídicos y éticos en la defensa especializada. De alguna manera ha dado guía para efectos de realizar una defensa bajo el paradigma ético. ¿En qué se diferencian estos dos programas? Bueno, mi abogado ve los casos de mayor complejidad, especialmente de niños separados de su familia que están en residencia, y el programa La Niñez y Adolescencia se Defienden toma estos casos antes, ¿ya? Para efectos de evitar, ¿ya? Que el niño sea separado cuando no se justifica, evitar la institucionalización, que es muchas veces innecesaria, porque como dije, es la primera medida de protección, recordemos que debe ser la última, y por lo tanto ambos programas funcionan de manera complementaria, o sea, antes y después. ¿Qué y cuál es el impacto de contar con un abogado a propósito de la experiencia chilena? Y como dije, no cualquier abogado, no cualquier defensa, sino que con las características señaladas. Lo primero es que inhibe la reiteración de conductas de agresión. El agresor o los agresores van a saber que el niño no está solo, ¿ya? Que el niño tiene un defensor, y no cualquier defensor, un defensor especializado y autónomo del Estado. Lo segundo es que contribuye a hacer visible al niño en el sistema judicial. Ahí, en el fondo, de alguna manera, los tribunales se tensiona el sistema y se logran que se tomen mejores decisiones. Y esto se traduce en una mayor protección. Al estar los abogados capacitados y ser especialistas, esto obliga a los jueces a tener una mayor capacitación en materia de derecho de infancia. Contar también con abogados permite aumentar la posibilidad del niño de vivir en familia, y esto es retornar a su familia de origen o estar en acogimiento familiar o familias adoptivas. Y de alguna manera esto hace que vivan en residencia y esto sea una medida transitoria, ¿ya? Evitando que la internación se perpetúe. Esto implica menos tiempos institucionalizados, lo cual contribuye al bienestar de los niños y además tiene repercusiones en aspectos económicos que al Estado obviamente le interesa, porque reduce los costos asociados al cuidado residencial, menos niños institucionalizados y menos tiempo. Y es una fórmula además para poder, ¿cómo se llama?, perpetuar y apoyar esta política pública que deberá ser una política pública de Estado, no una política pública de gobierno. Contar además con abogados ha significado evitar o disminuir más bien la desescolarización, ¿ya? Y además permite, lo que más nos importa en el fondo, avanzar hacia una justicia centrada en la niñez, con enfoques diferenciados, ¿ya? No es lo mismo una justicia centrada en las personas con una visión más de adultos que una justicia centrada en la niñez y adolescencia. Yo considero que es posible replicar esta experiencia chilena en otros países con dos condiciones. Lo primero, que sea una instalación gradual, progresiva, y en ese caso debiese preferirse a los niños que están en residencias, partir en fondo con ellos y luego esto escalarlo. Y si no es posible, por diversos motivos, implementar un programa con estas características, deben sí o sí implementarse reformas que aseguren el acceso a la justicia y al debido proceso reforzado, ¿ya? No es cualquier debido proceso, sino que es un debido proceso reforzado porque estamos hablando de niños con mayor vulnerabilidad. Finalmente, quiero terminar señalando que ningún niño, niña o adolescente víctimas de vulneraciones o delitos debiese enfrentar un procedimiento, y sobre todo judicial, sin contar con un abogado que le otorgue una defensa especializada, autónoma e interdisciplinaria en lo posible. Esto no se trata de un lujo, no es un privilegio, ¿ya? Se trata de un derecho y de una condición mínima para garantizar el acceso a la justicia. Muchas gracias.
Thank you, Esther. This was really enlightening, the importance of independent, specialized legal representation for children in the system, but also those who are at risk of going in the system is really critical. And the experience of Chile in that is very enlightening. We will be asking you further questions in the panel because I'm sure that the audience is going to want to hear more about that experience. But without further ado, I'm going to introduce Karabu Oza, who is the director of the Center for Child Law and a lecturer at the University of Pretoria in South Africa, where she teaches child law, social welfare, and education law, and children's rights in Africa. She's an accomplished litigator and advisor, and she's led landmark cases in South Africa's higher courts and serves on national and international expert bodies shaping child law and policy. Karabo, thank you so much for being here today with us. We're really delighted to hear from you. Your Center for Child Law uses the law in different ways to solve problems for children at risk, including those at risk of going into the alternative care system and those who are in the alternative care system. Can you please tell us how you've used the law to ensure children's rights are upheld, and particularly, or for example, when they're leaving care or when they're at risk of being separated from their family and caregivers? Thank you, Carol.
Thank you so much, Florence, and greetings to everyone. I think my focus of my contribution, I want to zoom in relation to children who are in migration situations, whether they separated, unaccompanied, or with their families. I think we are all aware of the fact that children in migration situations are some of the most vulnerable groups across the world, and how our countries respond to those children when they come into contact with the justice system is something that is critical. So let me start by sharing with you that in South Africa, already in 2005, there was a case taken to our court in relation to what needs to be done for children who are unaccompanied and migrant children. And that's because at that time, the children were being taken into detention facilities for purposes of deportation and being kept together with adults. And this case came to light, and the Center for Child Law and the Lawyers for Human Rights at that time decided to take this case to court with the aim of making it very clear that children who are migrant children who are unaccompanied or separated must be dealt with as children in need of care. So that means that when the police, when the social workers, or any other duty bearer comes into contact with those children, they must go through a children's court process where they are assessed. The possibilities of reunification with families in countries of origin are explored, and where such children cannot be reunified after all the efforts have been exhausted, those children are then placed in our care system, that being the alternative care, or we call it currently, we call the places where they are placed as child and youth care centers. Now, that is very important. It was a very positive development, because that is better than having children being detained and then being deported without anybody even ensuring where they're being deported to the perceived countries of origin, whether those children will have any form of protection in that. But now where we are after 20 years, of this judgment, before now and up to now, we started seeing that Once children are in the alternative care system in particular, those being the unaccompanied and separated migrant children, they are protected to an extent. They receive education, they receive health care, because obviously there is a protection through that court order that was granted. As they go towards aging out of the system, getting to 17 and 18, challenges start to emerge. The social worker started alerting us to some challenges. For instance, in South Africa, to write your final year of high school, you need an ID document. So social workers were sitting with numbers of children who cannot write the exams because they do not have ID documents. Then we have to think about how do we intervene. And this moment was also crucial because these cases are highlighting how when children get into the system, although they get the socioeconomic rights, there is a bit of a lack of planning of what happens to them when they leave the care, particularly because they have the court order. When they turn 18, if they're lucky, the court order can be extended until they turn 21. When you turn 21, then you don't even have a document that allows you to stay legally in the country. So that's one of the key challenges that these children faced, and we were trying to resolve with social workers. And when we looked at the case, we looked at our law and what could be done for them. In our legislation, there are provisions that allow you to apply for somebody to get what we call rights of permanent residence, that at least allows them to be legally in the country. Even though it doesn't give them citizenship, it does give them something to start working with, and then later they can apply for citizenship. So as we were being approached by social workers, we had to decide whether to do a case, what we call strategic litigation, because we do a lot of that, whether we should take a case saying all children who are in the child and youth care centers who've been there for a particular period should qualify for rights of permanent residence. But because of the pushbacks that are there, and most of you are familiar with it when it comes to issues pertaining to migration, these cases, we found that it was easier and more appropriate to actually do individual cases for the children as the cases come up. So I'll give you just two quick examples. We were approached with a case of a 18-year-old who just finishing matric, and he wanted to go into chef school, and he had actually obtained a bursary to do so, but he didn't have a document. So we were able to bring an application to get him rights of permanent residence, and that we actually did without much pushback from the relevant authorities. They gave him the document. On the other hand, we had M, who also was in a child and youth care center, and she was a brilliant student with very good marks and actually qualified to get into university. After we obtained as well for her the rights of permanent residence, the issue became the fact that she did not have any financial support to get into university. And what we had to do there for her, we had to actually launch litigation to challenge the policy that doesn't allow persons with rights of permanent residence to qualify from a national student funding scheme for universities. And we issued the court papers, and they were served on the respondents. But closer to the court date, they actually settled the matter and decided to change the policy to now allow for children who are in the same situations as M to actually be able to apply for the right for this national student funding scheme. And that was done, and M actually went and applied and continues. She is still studying because that's quite a recent case. But following up on these kind of cases, and I'll use again M because she remains in close contact with us, then we're able to bring an application for her to actually get citizenship, because there are provisions in our citizenship law that allows for, if you've been in this country for a certain period of time and you've turned 18 and you have nowhere else to go, you can apply for citizenship. That process is still ongoing though, because it is quite a tricky process. But what for us was very interesting and remains important about this case is the fact that when we started using the law to resolve the issue for these children in M situation, the social workers themselves realized how they also could be empowered to come to us or to even demand more themselves from the duty bearers. So even as far as asking for their superiors as to why must we wait for later? Why can't we do these processes so that
I think something has gone wrong with the internet for Karabun. Just waiting to see whether she's returning. It looks like the internet went down for Caribou. We're so sorry to be actually losing her at this time when she was giving us so many incredible examples of how legal representation and lawyers' access can strengthen access to services for those children in the care system as well. So very sorry to be losing. She's back.
I sincerely apologize for that. I do not even know what happened. It just
No
cut.
worries, Caribou. We're delighted
Thank you
you're
so
back.
much.
Please continue.
Maybe this is an opportune time to then move on to my second example. And here is where you have children who are in the system or in the country with their parents, and for some other reasons, the care system wants to get involved in their lives. So we had to bring a case which is under the strategic litigation, trying to sort out some gaps in the law because of a scenario where a father had been on the side of the road fixing shoes and had his child with him. But also at that time, there were other people, mothers who had been using children to beg on the side of the roads, who happened to be non-South Africans, foreigners from a neighboring country like Zimbabwe. And social workers went in to go and do this kind of mass removal of children from their mothers because they were using the children to use them for begging. And when they removed the children, they did not actually have a mechanism they didn't even inform the parents where they were taking the children and what will happen thereafter. So in the case of this, Mr. C, who we ended up representing with Lawyers for Human Rights, he made the case that he had actually taken his child on that day because his wife had gone to hospital to give birth. So he never used his child for begging. And in that case, in the end, the case ended up in the Constitutional Court and established two very critical things. The first thing is that when social workers or the people in the care and alternative system want to intervene, they must first try and establish and investigate before removal whether the removal will be appropriate. When such a removal is considered appropriate, there must be in the law a provision to say that within 24 hours, that removal must be reviewed by our Children's Court to determine whether it's appropriate. And the problem had been that when the Children's Act was drafted, there was no clause inserted in there for this automatic review of removal of children from their caregivers. Now, that was a good judgment that ended up with the law being changed by Parliament. And this was in 2012. Now, both cases that I've shared with you, both examples, and starting with the 2005 case, illustrate how you can use litigation, strategic litigation, or take case-by-case litigation to protect the rights of children, particularly in this case, migrant children who are in contact with the care system. But at the same time, while you're in that process, you can empower and educate those who are in the system, the duty bearers, to do better. We're sitting now so many years down the line where the same issues arise, but we are able to just write a letter and say, well, the 2012 and the 2005 judgments say you cannot approach these matters this way. So you must do better to avoid traumatizing the children and their families, but also to avoid us having to go back to court on matters that you should know better and should do better. So these are just examples. I see that they say I'm not audible. I sincerely apologize for that.
We can hear you very well. I'm not sure what's happening, but we can hear you very well.
Okay, let me then maybe conclude, and apologies that I got cut off. But my conclusion is that one of the key things in the care and protection system is for everybody to remember that we are not enemies, whether we're lawyers, we're social workers, and even the courts, because in South Africa, we actually even had to remind the courts that when a child who's an unaccompanied migrant child comes before you, it doesn't matter, they are a child first. It doesn't matter that they come from a different country. And using the courts, then following up with continued advocacy to continue the education, to train social workers. We're doing a lot of training still, so many years down the line on these issues because we want to minimize the risks and minimize the negative impact on these children. That remains very, very key. And I would say that if anybody has time, you can go on our website, the Center for Child Law. There are actually booklets we've created about how, for instance, the undocumented, unaccompanied migrant children should be assisted to get documents. So we give that to social workers and they educate the children. And then we also do a lot of work around how social workers respond to when children are in need of care and protection and are with their parents on the side of the roads to minimize the trauma to those families and to the children. Let me leave it there for now. Thanks, Florence.
Karabo, thank you so much for that contribution. Really interesting for us to be thinking about both sort of case-by-case approaches that help to secure the rights of children, but also the notion of strategic litigation to strengthen the law and how you've used that in South Africa in so many different ways, but in particular for these children who are at risk of being separated from their families. And I really loved the part about how you're thinking about actually the work you've just described, case by case and strategic litigation, really helps to empower those working in the system to do better and to understand actually what can be asked for, what can be demanded, if you will, to ensure children's rights are reinforced without actually even having to engage with any legal system at all. So thank you so much for that. And I think we'll come back to some of these examples in our questions and answer time in a little bit. So, and Karabo, you just disappeared briefly and then you came back and we could hear you perfectly. So it was just a brief interruption and it was really good that you came back because we were on the edge of our seat. We are also on the edge of our seat now as we're going to be hearing from our next speaker. I'm delighted to be introducing you to Benoit van Kiersbilk. So Benoit is Director of Defense for Children International in Belgium. He's also a chief editor of the Journal of Children's Law. And he might be best known at the moment for being an elected member of the UN Committee on the Rights of the Child. And Benoit has been a really fierce advocate, if I may say, for not just children's rights your whole career, I think, but particularly in relation to access to justice and effective remedy. And we will be watching out for the general comment of the committee in the coming year or so, which will be helping give us yet further strengthening to this agenda and clarity to governments about how that can be taken forward. So Benoit, as a founding member of this Global Working Group on Justice for Children, I am so delighted to introduce you and to ask you this question. So we know, Benoit, that the committee strengthens care reforms through its mandated activities in lots of different ways. What we'd like to ask you is if you could tell us about some of these mechanisms. We've heard about a few of them today already from Shima, for example, but could you tell us what you've learned about promoting access to justice for children in care and those at risk of being separated from their families from your unique vantage point?
Thank you so much, Jennifer, and it's a real pleasure to be with you today and with those great speakers that already paved the way of the discussion that we are having today. So, as you know, for those who are familiar with the work of the Committee on the Rights of the Child, we have three main mandated activities. Reviewing a state report and through a monitoring process, putting recommendation to states. And of course, through this process, we do analyze what is the situation of children in care, children separated from their family in each and every country. So we do see what is in place, if there is a de-institutionalization program in place, if there is a priority to family-based care, if there is proper access to justice in those contexts. And we try to put recommendations that are tailor-made as much as possible for each country and taking into account the specificities of the country and all categories of children, because we have heard today that many different categories of children can be separated from their parents and placed in a different kind of institution. So that's the first work that we are doing. And if you go through our recommendation, you will find that for every country, we have recommendation concerning children separated from their parents and put in institution. I encourage you to have a look at what we have said concerning your country. And if you think that we can even strengthen that, don't hesitate to reach out to us. We are always very open and keen to listen to comments and suggestions and receive more information. The second way, and it has already been mentioned today, it's the OPIC, the optional protocol on individual complaints, which covers two different mechanisms: individual complaints that can be lodged by a child or a representative of a child. I will come back on this in a minute. And then inquiries when there is a grave or systematic violation of children's rights. And Esther has highlighted one of our report that we have written concerning the situation of children in institution in Chile a few years years ago, and I'm happy to see that things are moving forward. It's very slow. We know that it takes time, but at least something is happening there. But then we also have general comments, and we have already issued 26 different general comments. I will not go through it, but you have many of them concerning the best interest of the child, hearing the voice of the child, but also children in street situation who are probably very vulnerable for being placed in institution, and then all the ones who are dealing with justice, child justice. And currently we are working on general comment, you mentioned it, Jennifer, on children's rights to access to justice and effective remedies that do recognize the specific vulnerability of children who are in institution, that aims to empower children as right holders and recognize them as independent legal standing, having such an independent legal standing, give special attention to children in care because they are facing much more difficulties and barriers when it comes to accessing to justice. We want to push states to put in place a real and effective mechanism, remedies, complaint mechanism, and appropriate supervision, oversight of institution, and also ensure that there is a place for the voice of the children, and the children should be heard in this context. So it has been said at length today, but we know that children who are separated from the parents are usually invisible, they are usually neglected. The justice system, but even the authorities do not look at them, or they tend to forget them and forget that they have also rights. And very often institutions are very close to deprivation of liberty or are equal to deprivation of liberty. In this context, trying to have access to justice is a huge challenge. How do you want a child with in a closed institution to reach out to someone who will help him or her to access to a remedy, to be informed about his or her rights, to be able to use the existing mechanism? We do understand that this is extremely complicated for everyone. We, as Committee on the Right of the Child, we encourage states to accelerate deinstitutionalization, because we know that institutions, even the best ones, if we can call them that way, will not be able to provide all the care and support that children need. We would like states to develop outreach and support services for families, robust monitoring or care institution and justice procedure, a clear mechanism for children to report abuse and seek redress. For a child who is living in the society, it's already difficult to reach out to services, to give a phone call to a helpline and so on. Imagine the difficulties that a child in an institution will face. So those mechanisms are extremely difficult to put in place in a way that the child will be able to use it, will understand, and without fear of retaliation or risk of being subject to further violence and abuse. If I may, I would like to share with you one concrete example that we have been dealing with through the OPIC mechanism, so an individual complaint. We received a few years ago, not that long, but the case of ML and others against Georgia. 57 children were living in an orphanage in Georgia, and they were facing huge difficulties to access justice, to know their rights, and to deal with the violation of their rights that were happening on a daily basis. The complaint was lodged by the director of an NGO, an NGO working with children with disability. And this NGO noticed that the children in that institution were not cared of properly. They didn't have access to the basic needs. There were systematic physical and psychological abuse by caregivers and other children, including beating, food restriction, forced medication, and degrading punishment. There were also several reports from the public defenders that were highlighting those shortcomings, those violations, and raising the voice of the children and asking the states to take action. But because of these reports, at one point, the institution decided to close the door to any external supervision or monitoring. And so nobody was able to enter into the institution to listen to the voice of the children, to see if something was going wrong. And the children themselves, as I said, didn't have any means to complain. So in that case, the director of this NGO took the case and brought it to the Committee on the Right of the Child. And the committee issued, first of all, an interim measure. It considered that the situation of those children was at high risk, and there was a risk of further harm and irreparable harm. And in that case, the committee asked the state to ensure that there is a supervision, that every case of abuse was investigated properly, and that there would be a follow-up of those complaints. So something moved slowly during the examination of the case by the committee, but at the end of the procedure, it's still quite long at our level, but it took 1.5 years, something like that. The committee identified that there were effectively a failure to protect children from violence, a lack of consideration to their best interest, a denial of access to effective complaint mechanism and legal aid. And legal aid is extremely important, as we heard today. And there was no proper monitoring and investigation of abuse, the allegation of abuse. So this example shows that if there is no external supervision, monitoring of such a situation, it can go on during years. It's not a priority for a state. It can be easily forgotten, and there is nobody that will take the voice of the child and bring it to the authority. And I think that one of probably the biggest difficulty that we are facing when it comes to children who are in institution, it's to find the best way to ensure that there is a remedy in place that is known by the children, that is accessible, and that can be used without prejudice by the children themselves, without risk of retaliation, without the risk of being banned, or that there would be a further abuse against them. Even, giving the proper information to children in a language that they will understand. And in this case, many of those children had disabilities, so more difficulties even to be able to access to the existing remedies. So in this case, the committee found that there were a violation of many fundamental rights of the children. They didn't have access to legal aid during the questioning by the police, or during forensic examination when they did complain about violence. The committee also found out that there was no rigorous child-sensitive investigation procedure in this case, and that there was a failure at all stages of the procedure. So altogether, we did find out many violations of children's rights. And what we did is, on the one hand, for each and every child, we did ask a reparation for the harm that they have gone through. and because each child deserves to be supported, and we ask to put in place a reintegration scheme for most of them, because most of them had a family, or to accommodate them in a family like service or institution. So to improve and accelerate deinstitutionalization, but also we ask the state to fix the systemic violation and the systemic problem that the child care system and the social protection system in the country. So effective monitoring, independent oversight of the institution, accessible complaint mechanism, and very important too, training of professionals on child right and child sensitive justice. So this is a concrete example to show that using those mechanisms that exist at national or international level can change the situation and can improve access to justice, and at the end of the day, the right of children who are separated from the family. Thank you very much.
Benoit, thank you so much. You've given us a great overview of both the ways in which the committee sets out some really important parameters and mechanisms to be able to realize children's rights, but also that example in Georgia really brings out it really illustrates, I think, the way civil society engages, the importance of all these different sort of levels, if you will. So not just civil society, but you were mentioning the way in which the ombudsman there was a separate system that kept that. So and you also really reinforced for us this important notion of just how harmful institutions are for children, and actually in this context of our conversation, how the isolation of institutions actually just reinforces the violation of their rights and the inaccessibility of access to justice, even more than children who might otherwise perhaps be in family-based care, who also will struggle to access their rights, but not nearly as much as children in institutions. So I think you just gave us such a really important overview. Thank you for that. This is our opportunity now as a panel and as a whole webinar. We have about 10 or 15 minutes, so not a lot of time, but for us to be thinking together about what we've heard today and where we go next. There's a million different ideas. We've got lots of questions from people, so thank you so much for your time that you've put in some questions in the Q&A for those that you have. And I will not be able to ask all of them because there are so many. And so Florence, you will come in as well to help us follow up with some questions. But I think maybe the first question I'd like to ask is to a few speakers to see who might like to speak first. And that is, let me just scroll down. So we've been talking quite a bit here about the multidisciplinary nature of the way in which children's rights can be upheld. We heard from several of our speakers about the role of social workers calling Karabo and the center to sort of make advance some of the rights that we were looking for. But we also heard from Esther about not just specialized lawyers, but specialized teams that are multidisciplinary, and the need for a psychosocial team that supports the work. And I'm wondering if we could just take a step back here to ask this question together and see who might like to answer. At the very least, I might ask Karabo perhaps, or Esther to start. But can you help us to understand the way in which these multidisciplinary teams work best together? What have you learned in the process of where social workers and lawyers are coming together, where they are not enemies, as Karabo, you've said? And what can we learn about how we overcome some of the challenges that is most important? If we were talking to people who were wanting to really solidify multidisciplinary opportunities, what would you say the most important, maybe top 2 or 3 points are to overcome these challenges? And may I ask Esther for you to come first, and then over to you, Karabo, if that would be fair to get that, both of your views? Just very briefly, your thoughts.
Sí, por supuesto, y muy buena pregunta. Lo primero es que estos equipos aportan un abordaje integral, ¿ya? Como dije, en el caso de la infancia y adolescencia, no es posible solo un enfoque jurídico, sino que hay que cubrir otras necesidades de niños, niñas y adolescentes. En el caso de los psicólogos, el aporte ha sido el hecho de poder guiar al abogado en las entrevistas para obtener la opinión del niño, guiar también al abogado para informarle al niño de su situación en términos de contexto, y también cómo expresar en un lenguaje claro y entendible para un niño, un lenguaje que además en el fondo tenga no solamente claridad, sea oportuno, sea pertinente, y adicionalmente que esa información no termine vulnerando, porque hay que considerar la debida protección también del niño, su interés superior de qué va a conocer. Por lo tanto, en ese sentido, el psicólogo es esencial. Y el trabajador social lo que hace es activar el intersector, activar la protección social, porque sabemos que la mayoría de estos niños, si no todos, corresponden a niños que provienen de la pobreza, ¿ya? Y por lo tanto, el hecho de contar con protección social es esencial. Participé en un estudio en que la conclusión es que la pobreza vulnera derechos fundamentales. Por lo tanto, la actuación de este trabajador social es esencial para activar el sistema, pero en términos de la estrategia psicosocio-jurídica, aportar al abogado qué es lo que debe solicitar al tribunal, ¿ya? Desde esta perspectiva psicosocial.
Brilliant. Thank you so much for that reflection, Esther. And Karabo, do you have any further ideas for us about that notion of multidisciplinary engagement? Or how do we overcome?
Yes, no, I mean, I agree with what Esther said, but I also think from a systemic point of view, it is important to also establish bodies of these multidisciplinary experts that kind of oversee or over a long time. So for instance, in South Africa, we have a steering committee focusing on unaccompanied and migrant children. And there's meetings every third month, and there you start engaging, and people, you disarm people and are able to build together. And also now and then they know that if they're stepping out of line, we'll say, well, we might go to court if you're not doing the right things for the children. But that has enabled us to actually have people, it sits under government. So with government officials, with social workers being represented in the forum, we have a continuous way of discussing the issues and questioning, and sometimes even saying in some of the cases they presented that, well, no, you're not doing right by the child. We actually want to represent the child. And you start now shifting the mindset. So I think also systemically we need mechanisms that make sure that not only are we overseeing the centers where the children are, but the officials and the people who work with those places, their knowledge is being tested, and you always are aware of where their thinking is, particularly when you're dealing with, for instance, unaccompanied migrant children, because there we know issues can easily get very tricky. So when you're in the room with them all the time, you're able to influence them and have continuous oversight.
Really interesting. Thank you. So we'll keep thinking about that notion about engagement, but also at different levels. I think, Karabo, you're telling us is the importance of not just multidisciplinary teams, but also multidisciplinary mechanisms that enable the kind of accountability at multiple levels to ensure that we keep that system on track and respecting children's rights. So thank you to Esther and Karabo. I'm going to hand over to Florence, my co-moderator, who has some more questions for the panel. So stay with.
Thank you. There are lots of great questions, and as Jen said, we're not going to be able to answer them all, but we'll definitely note them and try to get answers for you afterwards. One of the questions that was asked is in relation, we've talked a lot about the importance clearly of legal representation, assistance, multidisciplinary team. But what, in your experience, and this is a question that can be answered by any of the panelists who want to give a go at this, but what, in your experience, can be done to ensure effective legal assistance and representation in countries that actually have weak legal systems, where there are few lawyers and available mechanism to support children to access to justice? What are some of the ways we can encourage not only strengthening the justice system, but encourage lawyers, legal institutions, and others to actually support the advocacy of children facing violation in the system? It's a difficult question.
Maybe I can just share a few ideas because we have been discussing this while drafting the journal comment 27 that will be issued next year. And as you may know, we have had a lot of contribution. We made a call for submission, and we received a lot of very interesting contributions. So that's absolutely great. And I would say that we have many examples of states that put in place small group of lawyers who are specialized or specializing in children's rights, working with social worker, with other professionals, very often reaching out to children, to families, to communities, and so on. So that's an important dimension because even the best lawyer, if he or she remains in his office, will not be accessible for children. So that dimension is very important. But we also know that this has its limits. And one of the mechanisms that we have been analyzing, which seems to give extremely interesting result, is what we call social legal defense center. So centers that are working with social worker, lawyers, who can inform the child, who very often are in the community. They are providing several services, and they're known and accessible for the children for many reasons. And this is a place where the child can disclose information, disclose problems that he or she would have. They work also with the school, with the local authorities, and with this multidisciplinary approach that we talked about. Because again, I think that when a lawyer intervenes, but there is no possibility to follow up and to work with the family, with the community, the work that the lawyer can do may be too limited in this context. And in the example that I gave, the fact that an NGO intervened, the Ombudsman for Children intervened, a lawyer was appointed for every child in this case, and so little by little access to justice was better guaranteed. So this could be one avenue, and it doesn't cost that much. Of course, there is a cost for the society, but fixing human rights violation is much more important, and on the long term, we know that it's more effective.
Thank you, Benoit. That's a fantastic example. It'll be great to actually learn from that practice in those countries and to see the general common building on that practice. Thank you. That's really helpful. Jen, over to you.
Thank you. I'm going to ask Benoit to stay with us here for a second because I have a question for you. So we're thinking together about the structural violations in residential childcare, and we have a question about countries who haven't ratified OPIC and who then mean they can't access the very mechanisms that you've described. And of course, we are hoping that countries will increasingly ratify OPIC. But in the meantime, do you see any other alternative to the kinds of inquiry you described in the context of Georgia? So I'm reminded of the presentations of Jaden and Kira during the Children Deprived of Liberty conference in Geneva last year, where it showed that there were different kinds of approaches to reducing institutionalization for children for care purposes. Are there other mechanisms that you see for countries that haven't ratified OPIC that you could mention?
Mm-hmm. Thank you. First of all, I would recall that when there is a decision from the committee on one individual case, the lesson learned and the position of the committee is applicable to all states, because this is an interpretation of the convention of course, in a specific settings, but we can draw lessons from this specific case. But then the OPIC, of course, we encourage all states to ratify the OPIC. But first and foremost, we want states to put in place access to justice at national and even local level. Because we know that international justice will never solve all the needs for justice that exist out there. And that there is a need for the proximity, the very close relation between the child and the ones who deliver justice. This is extremely important. And then we should also remind that there are other mechanisms at regional or international level. In Africa, the African Charter for the Right and Well-being of Children also has a mechanism of individual complaint. It exists also in Latin America. So you have other mechanisms that you can use in case your country has not ratified the OPIC, and then states should put in place also a non-judicial mechanism like ombudsman for children complaint, administrative complaint mechanisms, and so on.
Thank you, Benoit. That's really helpful and begins to open up the thinking for us beyond what we've even thought about so far. So I think we have time for one more question. And Florence, that's for to you to ask it.
Yes, thank you. One final question, and this one may be directed to Nimu if we can. There are a couple of really good questions asking the question around how children and young people can participate better in policy development in relation to advancing their rights. And that includes as well in the design of justice services. In your experience, Nimu, what are your recommendations about participation of children and youth, including care experience, children and youth, and justice system experience? What have been the examples that you've seen where they have been involved into the development of these policies and services?
Yes, thank you, Florence. Actually, your voice was breaking up, but anyway, I thought I got the question. So, but I already mentioned that there are there are a lot of summit and webinar that we have been taking part, especially all the care leavers. So we have like a care leavers council, we have a global care leavers committee, we have separate care leavers network all over the world. That even currently I am also have joined with them. So if we can have kind of awareness session, or if we can train them, the care leavers, as from the expertise, if care leavers can be trained, and care leavers can definitely get the responsibility of going for the child development children's homes in their own countries, and they can be be kind of influencer, or they can be kind of a people that who are giving the knowledge for other children who are living in children's home, because the children who are in the care, they really wanted to listen, and they feel confident to talk with the care leavers more than others. So it's better that if care leavers can be definitely trained on this, definitely they can be take the leadership role to make the children who are living in children's home having kind of a faith on the people, believing in the people, that we can share anything, that we can share our whatever the injustice is happening, we can share, there is someone to share. So I think through the care leavers, if anyone, if policymakers can go to the children's in care, that will definitely affect.
That's a fantastic suggestion, Nimu, and it really highlights the power and the importance of care experience networks and individuals, both young people and children who have left care, as experts in the system themselves, and with the right training and support as advocate for the changes that are needed for the services. No one else is better placed than those who've actually experienced the system as to what needs to change. So that's a fantastic suggestion. I think we are running out a little bit of time for the Q&A. Jen, maybe let's move to our final speaker and the next the closing of this webinar, if that's okay. So without further ado, it's going to be my pleasure to introduce our next and final speaker, David Bailey. Welcome, David. David is a UK civil servant with nearly 15 years experience across the Department for Communities and Local Governments, Department of International Development, and FCDO. And he currently serves as the head of the Children's Care Reform campaign that we mentioned earlier on, bringing expertise from roles spanning from climate finance, nutrition, youth, and civil society. So we're really glad to have you here with us, David. So David, we've spoken a tiny bit about the global campaign. We'd love to hear more from you. It is mobilizing significant political commitments from a whole range of actors, primarily countries, building on commitments that are already made and that have been made through the Global Charter, to encourage them to concrete actions and collaboration. Having heard the experience from the panelists today, What do you see as the opportunities to better integrate efforts to advance children's access to justice as part of these efforts to reform the care systems globally?
Great. Thanks, Florence. Thanks, Jennifer. Thanks to everybody who's participated and remained on the call. I promise I won't keep you for more than a couple of minutes. So yes, a really good opportunity just to talk a little bit about the campaign and also address that question about access to justice. So for those though, in the chat bar, I think there's been some links to some documentation about the campaign, but David Lammy, when as Foreign Secretary, when he came into government in the UK just over a year ago, launched a campaign with the aim of ending the use of institutions for children's care. And this seemed like an almost universally supported ambition, going with the flow of UN Commission on Human Rights kind of guidance and work with Africa Union and lots of other work, all heading in the same direction. On the face of it, relatively straightforward, but of course, as this webinar has already demonstrated, actually putting this into practice is anything but straightforward. And the amazing speakers have all demonstrated really eloquently the complexity of system level change and transforming systems, but also have really demonstrated the passion that so many people have for making those changes and the progress that's being made in many different countries around the world. So while it's a difficult time for many of us working on different global issues, I'm really positive about the potential and the possibility that we have of really transforming systems so that every child can grow up in a safe and nurturing family environment, which is really what the global campaign on children's care reform is all about. As Florence already mentioned, we launched a global charter on children's care reform in September at the UN General Assembly this year. Over 30 countries have already signed, and well over 100 organisations have endorsed. And that commits those countries and organisations to supporting families to prevent unnecessary separation, ensuring safe family-based alternative care, tackling harmful and unacceptable practices that incentivise institutions, and investing in the key enablers that support improved services for children and families, and that's really important in terms of some of what we've heard about in terms of access to justice already. I see this issue of children's care reform as both a human development issue and a human rights issue, and access to justice is fundamental to both. So on the development side, we've already heard today about how access to justice can help address some of the root causes of breakdown and separation, discrimination, poverty, lack of access to services, enforcing entitlements and connecting families to resources could really help stop the flow of children into harmful institutions and into alternative care. And then on the right side, we need to ensure that children and families have the ability to challenge unnecessary separation, to seek remedies when rights are violated, and be heard in decisions that affect their lives. And the global campaign will continue to be shaped by the experiences of those who've experienced the care system and experienced the justice system. And care reform and justice reform have to work hand in hand. And governments can and should lead by creating integrated strategies that link the various different services that support children, that support families, that support communities, and child protection and justice. So I'll just conclude by saying that access to justice is not an add-on. We see it as fundamental to the campaign, and by embedding justice into care systems, we can uphold rights, prevent harm, create pathways for accountability, which is so important when we're looking for how our children are looked after in families and communities and by states. So, as I said, and just for fear of slightly repeating myself, working on global issues as I have for many years, and many of you on the call have and continue to do so, can be quite difficult, and there can be a lot to be down about. But I'm really encouraged by what I've heard this afternoon and by the work that I've been doing over the last few months, by everything that's going on around the world to build and sustain strong families, strong communities, and systems that truly serve children and families. And so just to anyone on the call who's who's kind of staggering towards Christmas and maybe a bit of a break over this kind of festive period, to keep going. Encourage your organization or the country in which you work to sign the Global Charter if you haven't already. Information's in the chat. And again, just thank you for Jennifer, Florence, and all the other people who've helped organize this session. Keep going, keep working hard, and I hope to speak to many of you again. Thanks.
David, thank you so much. That's a really inspiring finish to our webinar today. And I think the leadership of the UK government has been really important here in keeping the spotlight on the issues that are facing these children and their families on a daily basis. So can I just say thank you for joining us, but also thank you for the leadership of SCDO in this agenda. And I'm sure there are many other governments that are keen to follow your lead in signing this charter, but also coming together to form a coalition or a collective to ensure that this is held across the world in terms of the ambitions that you've just held up today. I loved your notion of pathways to accountability, and that care reform and justice reform have to be hand in hand. That's a fantastic phrase, and I think that's exactly encapsulating the purpose of our session today, is to really think, how do we do that? How do we hold these reforms hand in hand in order to ultimately realize what we are striving for, which is children's rights, and particularly upholding the rights of children in alternative care or at risk of separation. So fantastic. Thank you for that ending. But let me just hold you here for 1 minute more, if I may, to say, well, that was a fantastic closing to the session. It was a rich conversation for the whole time. And I know people put time and effort into preparing for this, and thoughtful contributions we heard from everyone, from Shima, from UNICEF, Nimu. Thank you for your bravery and your endless advocacy that we really benefit from. Esther, what a really interesting input from specific technical contributions, technical developments in Chile that is world leading for us to be learning from. Karabo, you've introduced this whole notion of both case to case and also strategic litigation, and how that form can be so important to being able to really scaffold and reinforce the rights being realized for children. And then Benoit, you've taken this right up to that international level of thinking, and how do all these mechanisms work at every level to really realize children's rights and access to justice in alternative care and care reform. So fantastic. Thank you to our speakers. Can I say that there are some next steps you might be pleased to hear about? The next step, I understand, which is really exciting, is that there's a new technical brief that UNICEF will be leading on in their Reimagining Child Justice, Justice for Children series that will be focusing on access to justice and children's care reform. So please stay with us on that and be engaged with that as we go forward. We think there will be many other opportunities to engage on this combined agenda because it's so important. And so we will follow up with you following this webinar with the recording, with the URLs that have been shared, because there are millions of them. I don't know if some of you have now got millions of tabs open on your computer from clicking on some of these that Elena has so kindly put into the chat. But thank you for that, and we will follow up to make sure you have what you need. I think the last thing to say is then all of this is happening because we have some phenomenal people working in the background. So can I just say thank you so much to Annie, to Aminul, to Kirsten, to Mia, to all our partners, Elena, who's pulled together the webinar, Sophie from my team, who's also come in to reinforce. It's a big team effort here, and we are all delighted to be able to do that together. So can I wish everyone an excellent rest of the day or night, depending on where you are. Thank you so much to you for joining us, and we look forward to staying in touch on this really important agenda that is gaining momentum, and importantly so. Thank you, everyone. Bye for now.